It is necessary to understand the origin of the court of equity and to some extent its history. What is equity? I do not know that any definition of equity that can be found would be an improvement upon Aristotle's definition, which is, in substance, that, quote, equity is the rectification of the law when by reason of its universality it is deficient, end quote. Beach, in his work upon modern equity jurisprudence, there's that word, says, page 1, quote, the equity jurisdiction arose out of the inability of the courts of law through the inflexibility of their rules and want of power to adapt judgments to the special circumstances, to reach and do complete justice in all cases, end quote. If we consider the causes out of which the equity jurisdiction was evolved, no better statement, therefore, can be given than the foregoing. But in answer to the question, what is equity? I much prefer the definition given by Blackstone. Quote, equity, in its true and genuine meaning, is the soul and spirit of all. Positive law is construed by it, and rational law is made by it, end quote. But whatever difference there may be as the true definition of equity, we know that the system of department of the law known as equity jurisprudence had its origins in the fact that the common law of England, which had been sufficient and answered its purpose while the people were semi-barbarous, was found to be totally inadequate to meet their wants as they advanced in commerce and civilization. Like all systems of law, springing from the customs of the people and founded upon traditional maxims, it had become harsh, unyielding, administered upon technical rules with a blind adherence to established maxims and precedents. At common law, no writ could be made to fit every new case that arose, and the struggle of the courts became to make the case fit some writ in existence. And when this could not be done, quote, wrong went unpunished and right often unvindicated, end quote. The king was recognized as the fountain of all justice, and applications were made to him as such, to great relief, because no writ known to common law could be found to fit the particular case, and no precedent had been established upon which it could be adjudged. The king, being bound by no established precedent, granted such relief as the nature of the case required.